Good morning. Welcome to Labor, Health, and Social Services Committee. Good morning, committee members and members of the public, LSO, and Ms. Peters, our LSO intern, and members of the public. Thanks for joining us. We will go ahead and call the meeting to order at 8 a.m. And Mr. Caldwell, if you'd call the roll.
Representative Clouston.
Here.
Representative Guggenmoss. Representative Heft. Representative McCann. Representative Ottman.
Here.
Representative Thayer.
Present.
Representative Wasserberger.
Here.
Representative Yin. Chairman Rodriguez Williams.
Here.
Madam Chairman, we have a quorum.
Thank you, Mr. Caldwell. All right. We have a pretty seasoned audience here. So I won't go over rules of decorum. Committee members and members of the public, just remember to keep your phones on silent during the meeting and address the chairman and abide by our general rules of decorum. All right, we will go ahead and today we're going to actually, or this morning, we're going to have two bills that we're going to consider. The first one is Senate File 10, and it's now on the table for consideration. And we have with us the good Chairman of Judiciary. Welcome. Good morning. If you'd state your name and walk us through your bill.
Good morning, Madam Chairman. Art Washit, Chairman of House Judiciary. So pleased that I think this is probably the first time I've testified before your committee, and this bill came through the interim as a joint judiciary bill. You have experts in the room agency personnel who have much more in-depth knowledge about what this bill is going to do for their agencies. But I just want to remind you of where it came from. The beginning of this bill came with a letter from a sheriff who said the department owed him lots of money for all the days that inmates were spending in his jail awaiting transfer to the state hospital. Why are the inmates sitting in jails waiting for transfer to the state hospital? Because for as long as I've been in the legislature, the state hospital has not been able to timely receive all of these inmates who are being these are inmates who are on the criminal side, not on the mental health side, not on the Title 25 mental health holds, but these are the criminal defendants who have been found to have a need for a forensic examination because of the question of competency. Are they mentally competent to stand trial? And if they are found to not be mentally competent to stand trial, then they go through a period of restoration where the state hospital tries to restore their mental health so that they are able to then stand trial. When the state hospital is unable to timely receive a transfer of these people into their facility, you get a backlog. And those inmates can't proceed through the criminal justice system until they are deemed competent to go forward. And thus they sit. And sometimes they're only in jail for relatively minor misdemeanors, but they can't even go to trial on that minor misdemeanor until they're deemed competent. And now they're spending months incarcerated for a crime for which they would never receive that much jail time if they were sentenced. In addition, you also have felons, people who are charged with felony crimes, who are awaiting trial and who have been found by the court to have a question of whether they are competent mentally to go forward. And so for a variety of reasons, the state hospital has not been able to receive these inmates. My first recollection was they were in the middle of a major rebuild, a remodel. They were tearing down old buildings and building new buildings. And so, boy, as soon as we get those new buildings done, we'll be ready to take these people as quickly as they need to be taken to the state hospital. And about the time we got the buildings done, we get COVID. Now we need elbow room between patients. We can't have them filling every room in the hospital. So that creates a delay. Then post-COVID, we can't hire enough staff And so there are still beds available, but no staff to allow these inmates to be transferred from jails to the hospital. The director from the department that takes care of health issues recognizes and has done great work trying to address these issues, but he lacks a mechanism by which he could even statutorily reimburse sheriffs for even part of the time that these inmates are spending in their jails. So that's what this bill does, is it creates a mechanism by which the Department of Health and individual sheriffs can enter into a contract so that the Department of Health can compensate those sheriffs for the time that these inmates are in their jail. And it gives great flexibility so that if an inmate is in a jail where some mental health care can be provided, because there are providers in that community who can come into the jail and work with that inmate, maybe then the restoration phase at the state hospital is shorter, because instead of just languishing in jail and their mental condition deteriorating further, they're receiving some level of care, and thus they're not getting worse, they're getting better before they go to the state hospital. So we get a shorter time. So depending upon the extent of services that the sheriff can provide, the department will enter into a more lucrative contract with that sheriff. If all a sheriff can offer is a bed and a place for that inmate to wait for their turn to go to the state hospital, then they're going to get less reimbursement because they're not having to pay for mental health care. We think this is to steal the phrase from a representative from Sheridan, an elegant solution that gives us an opportunity. We do something very similar on the conviction side. When an inmate is convicted in district court of a felony crime, and there's a delay of more than 10 days before the Department of Corrections can come get that inmate and transfer him to the state prison, the Department of Corrections has a budget to reimburse the sheriff for each of those days beyond 10, where the state inmate who's been convicted of a state felony is sitting in the county jail waiting for transfer. And so that's basically the model that this is drawn on, except that this one allows a variety of compensation agreements based upon the level of care that might be provided. It's also hoped that if in some of our bigger counties where mental health care is available in the jail for those inmates, that can shrink or maybe even remove the need for that inmate to ever go to the state hospital, which means that we can pick up the cycle for those counties where inmates don't receive mental health care in the jail, but will take advantage of the fact that stays are shorter or fewer inmates are actually needing to come to the state hospital. So even for those counties where mental health care may not be available for inmates, there will be a benefit to those sheriffs if this bill becomes law. And so that's what I wanted to do for you this morning, Madam Chair, is kind of lay out what we're trying to do with this bill, and the great people behind me can fill in the details. But I'll happily stand for questions if the committee has any.
Thank you, Chairman Washut. Committee, any questions on the bill for the good chairman? Vice Chair Ottman?
Thank you, Madam Chair. Chairman Washut, could you just give me an idea of where these detention facilities are that would have the mental health capacity to do that?
Chairman Washut?
Madam Chairman, Representative Ottman, certainly in your bigger counties, Casper, Cheyenne have access to some mental health care. But I'm certain there are many other counties as well that Director Johansson can identify for you.
Okay, thank you.
Committee, additional questions of Chairman Washut? Okay, seeing none, thank you for joining us this morning
Thank you.
on such short notice. I appreciate it.
Appreciate it.
All right, are there any government agencies that would like to come forward on Senate File 10? Good morning, gentlemen. You'd state your name and we'll hear your take on the bill.
Good morning, Madam Chairman, members of the committee. Stefan Johansson with the Wyoming Department of Health, joined by Franz Fuchs, our Deputy Director. Just some brief introductory comments and then happy to answer the committee's question. By way of background, this bill, as the good chairman mentioned, came from really the financial issue. We have a wait list at the state hospital on the criminal forensic side, and who bears the brunt of that wait list are on these patients that are sitting in detention centers are the sheriffs and your county jails. We are acutely aware of that, as we've told this committee and others multiple times. The wait list right now of about 3 to 6 months to get inpatient to the state hospital is not something we like, we prefer. We want those patients in as quickly as possible as soon as we receive an order, but it really comes down to the capacity that we have at the state hospital. So 3 things that really drive the volume here and what created the original conversation is the volume of court orders that we get. And that can be for forensic evaluation to determine if someone is competent to stand trial. And then depending on the result of that evaluation, if a court orders restorative services, inpatient restorative services at the state hospital, we are compelled, obviously, to receive and treat that inmate, that patient. That volume of orders over the last 5 to 10 years has grown significantly from the judicial system, which puts a strain on the capacity that we have. As Chairman Washit mentioned, the second dynamic here is really the number of available beds. We operate a 104-bed state hospital. About 28 of those beds are forensic or criminal beds for this Title VII population. The remainder is generally dedicated to Title 25 civil commitments through the civil commitment process. So with that capacity, that's essentially the number of beds that we are trying to serve the judicial system statewide. And with that growing volume of orders, it has become difficult over the years. And the third dynamic, as Chairman Washit mentioned, is staffing. You all are well aware of our difficulty at the Department of Health, especially in our safety net facilities, like the state hospital. Direct care is just hard for us to recruit right now with what we offer for CNA wages and nursing wages. Our state hospital staff in the last year and a half have done a great job reducing our vacancy rate of CNAs from over 50% about 18 months ago to around 15% today. So some progress has been made, but it's still very difficult for us to have the adequate number of nurses. So we pool that vacancy savings that we have from those vacant positions, and we buy a smaller amount of much more expensive contract labor, which we do reluctantly, so that we don't have to further reduce bed capacity for the courts, for the jails, for the sheriffs. So those 3 dynamics, Madam Chairman, members of the committee, are why this is a structural, capacity problem. It becomes a problem for the sheriffs and detention centers on a couple of different fronts. That about a year ago, a lot of discussion was being had, as Chairman Washit mentioned, some letters being sent. Hey, you're not reimbursing us for these wait times that we have to get into your state hospital. True, fair. We don't have a legal mechanism to do that. So in the Title 25 area, the civil commitment, there's law that says after the first 72 hours of Title 25 civil commitment, the department shall pay the cost. We pay, the emergency department or the provider that's holding that Title 25 client while they're awaiting admission to the state hospital. On the Title VII criminal side, we just don't have that statute. So that's really the first mechanical thing that this bill does, is open up a permissive ability for my department to even be able to reimburse the detention centers. So last summer, in that discussion of, well, let's talk about reimbursing detention centers, sheriffs, jails for this. And I'm really proud of the work with the help of Alan Thompson from WASCOP, who you'll hear from, and so many sheriffs over the past year and really longer than that worked with us. We had multiple work groups to determine what could we do, how could we do this better? And there was pretty universal agreement that just allowing the department to reimburse and say, here's some money to offset the cost of that detention doesn't address those first 2 dynamics that we talked about. Are we making the system more efficient, better, et cetera? And so the group came up with more of a tiered structure. the bill looks very simple because it's permissive. It opens up this possibility. But if you look through it, it'll allow the department to enter into agreements or contracts to reimburse for the security, examination, and treatment. So kind of a tiered way that, as Chairman Washit mentioned, we can work out a per diem reimbursement at a certain level after a certain time, similar to what you see in the Department of Corrections. But for those detention centers that could work with us, use Department of Health programming, other support, which I can talk about, to decompress the system, actually reduce that wait list, stabilize people in the detention center, and potentially reduce not only our wait list, but that would mean the wait list for your other county detention centers. Could we partner together to figure out a way to do that? And that really stemmed from several different ideas, programs that you all have been aware of over the past couple of years that I think we can leverage to make this even better. In certain counties, we have agreements for Title VII diversion for very low-level misdemeanors who the county attorney, the local community, local control believes they really shouldn't be on the wait list for the state hospital. As Chairman Washit mentioned, this crime, stealing a candy bar from the convenience store, yes, it happened, but there's a very significant, serious mental illness, schizophrenia, schizoaffective disorder. This person is sick. And rather than wait 6, 9, 12 months for the legal process in Title VII to unfold, could we divert that, stabilize the person, get them into community treatment while the county attorney holds those charges in abeyance? That's operating in a few counties right now as a pilot program. But in addition, the Department of Health offered a little more than a year ago, designed a telepsychiatry program. Again, as part of these issues of money is one thing, staffing is one thing, but ability to treat or stabilize clients is a difficult thing to build. So with a few county detention centers, we executed some agreements for the Department of Health to provide an MD level psychiatrist using telehealth, which is something Wyoming is really needs to do given our large geography and very limited access to psychiatrists, to provide direct care and consultation to the detention center. So you get a very sick individual in your detention center under Title VII, and just think of the folks, to give you crude examples, extremely violent, self-harming, aggressive towards detention center staff, all of the things that you can imagine. It's not for everybody, but you do get these clients that are inordinately difficult to care for because of their behaviors and their psychiatric conditions. And in those cases, having the ability to treat, whether that's treatment or medication to stabilize, can be a huge benefit to not only the jail, but again, to the overall judicial system that involves the state hospital to provide that rapid access to stabilization. So we have been doing that with the detention center in this county. We have agreements in other counties, one developing, potentially inked this month. And in my view, it's working very well. We've seen clients stabilize and go back to general population. Essentially, we don't need to proceed with the Title VII process because we've been able to do that restoration or stabilization locally. And that's something that we think, given this very simple bill that permits the department to not only reimburse for the detention or security of these inmates, but incentivize or allow participation in those broader treatment programs that we already have or that we could build, really does create the potential for us to make some changes and some improvements to what has been a very frustrating performance issue for the Department of Health, for the judicial system in general, because everybody is just trying to treat and serve these patients, these inmates, as quickly as possible. With that, Madam Chairman, members of the committee, we're very supportive of the bill. This was something that came out of that work group between the sheriffs, the Department of Health, that was proposed to the Joint Judiciary Committee under their interim topic. And we've greatly appreciated the dialogue. And I have to say on record, I've been here for a while, and it's very easy with courts, county attorneys, judges, law enforcement, sheriffs, and Department of Health to all point fingers at each other. Believe me, we've all done it. And just blame one or the other for why this problem is happening. But I have to really commend our law enforcement, our sheriffs. We've been working and having very intense but productive dialogue for a couple of years. between myself, my staff, and theirs, to try to see if we can make this better on the margins while we really try to improve the overall system. And Madam Chairman, I believe this bill is another tool in the toolbox to have us do that. Final thing that I'll mention, the Joint Judiciary Committee, when they considered this bill as a committee bill, it had an appropriation in it. So one of your questions might be, well, how are you going to reimburse them? It's a good question. The Judiciary Committee during the interim stripped that appropriation out in favor of having that go through the budget process. Timing was an issue because when they were considering the bill, I had already submitted the Department of Health's budget for consideration by the governor. So, putting that back in, it was just a timing issue. But there was a concern that if we're going to do this, have the ability to do it, how do we finance it? Your Joint Appropriations Committee, through a footnote that you'll see in the Department of Health's budget, has put a $5 million biennial appropriation to support essentially the elements of this bill to allow the department to have those resources to support your county detention centers and your sheriffs. Madam Chairman, long-winded explanation. I appreciate your time this morning, but Franz and I are happy to stand for any questions.
Thank you, Director. Love the collaboration behind the bill. Committee, any questions? Representative Clouston.
Thank you, Madam Chair. Thank you, gentlemen, for being here. Good to have you. So a couple questions. You answered a lot of my notes, so I'll take these off. But first question being, how many citizens are we talking about that are in this situation?
Director.
Madam Chairman, Representative Clouston, as I mentioned, we operate between 25 and 30 forensic beds at the state hospital. So just in fixed capacity. I say about, it's not because I don't know, but that can shift in the facility when we need to, have some wings or beds dedicated to Title 25 more because of certain situations, or Title 7 populations more. But that's the fixed capacity. And I believe we have 31 on the wait list today. So at any given time, you're really talking about anywhere from 80 to 100 individuals that are potentially in or adjacent to the Title 7 system.
Follow up, madam.
Follow up, Representative Clouston.
Thank you, Madam Chair. And then with these rural healthcare transformation funds coming, do they qualify at all for something like this?
Director.
Madam Chairman, Representative Clouston, yes and no. So we don't have anything in the Rural Health Transformation Plan that was approved by the federal government that would be specific to this population. And there's a reason for that. The federal requirements and guidelines on those funds were very clear from the beginning that you can't use these funds to increase reimbursement rates for a service that already exists, to do new capital construction for new facilities or new beds. So those limitations kind of prohibited the state and all states from saying, well, we have this problem in this system, let's just juice it with federal funds for 5 years. That's not something that's generally allowable. However, with rural health transformation funds, I think there's broader system implications there for mental health crisis stabilization. We have some EMS crisis stabilization initiatives put into that plan, kind of at the law enforcement and EMT level that are responding to those calls. So there's some adjacent elements there, but not specifically or explicitly directed to this problem.
Committee, additional questions of the director? Vice Chairman Ottman.
Thank you, Madam Chairman. I was just wondering, down there at 28 beds, how is it divvied up between male and female?
Director.
Madam Chairman, Representative Ottman, I can get you a current breakdown. We try to be dynamic with that because we just don't know the orders that are going to come in. So yes, we do have some fixed capacity for male and female sections, both in terms of Title 25 civil and this Title 7 forensic. But we try to be flexible with that. So in any given month or quarter, if we see a large volume of a certain type come in, we'll try to adjust the physical plant capacity to accommodate that. But we obviously do, have that differentiation in the facility and don't have units where they're all together.
Follow up.
Thank you, Madam Chairman. So with your personnel, are they flexible then going back and forth to accommodate that? And also, what is the youngest that would be there?
Director.
Madam Chairman, Representative Ottman, it's a good question. To your first question, yes, we try to be flexible with the staff. It really depends on the expertise, the supervision we need, depending on the acuity of the client. So we do have enhanced units at the state hospital for extremely acute, extreme behavior where it can be very dangerous, just like your sheriffs and detention centers will tell you, very dangerous, not only to staff, but to other patients, other residents of the facility. So we try to be flexible with that. In terms of the age, I want to be clear, we don't control the orders that come in. We are a safety net facility. So if we get a court order for admission to the state hospital, we are compelled legally to admit that client. Now, having said that, we do not provide adolescent services at the state hospital. Decades ago, there was an adolescent unit at the state hospital. But I think when you talk about civil rights on the Title 25 side and then criminal civil rights on the Title 7 side, generally assumes adulthood there. There's processes, for juvenile justice in other areas of statute that don't necessarily contemplate the state hospital. But Representative Ottman, we have and do on occasion get orders for minors, both generally on the Title 25 side, usually not on the criminal forensic side.
I have one question, Director. Is there a mechanism in place for reimbursement for, say, for example, somebody who's already established care, perhaps with the VA or through a private provider? Is there any sort of reimbursement mechanism that the state has in place?
Madam Chairman, it's a great question. So again, separating the two sides of the house, on Title 25, the civil commitment side, which is not this population and what you're considering today, the answer is yes. So both in terms of psychiatric hospital level of care, like you have at my facility or in Casper, and Ivinson Memorial in Laramie has some psych beds, we can reimburse at that level in Title 25. Then the statute also allows for other treatment providers where we have enrollment and rules that are at a lower level of care, things like outpatient observation, holding in an emergency department. So on the Title 25 side, yes. On the Title 7 side, for folks that are being held in detention centers, no. And that's really what this potentially opens up.
Thank you. Representative Wasserberger.
Thank you, Madam Chair. Thank you for presenting this today. Just out of curiosity, what is the most common type of mental health issues that you see coming through in these institutes that you guys are holding people at while you're waiting to get them into trial?
Director.
Madam Chairman, Representative Wasserberger, it's a really broad list. And again, we don't have a filtering mechanism that we can tell the courts, hey, we don't take this type of person or this type of person or this type. We try to work with the courts on what we can and can't do. So for example, if you have someone that is ordered to our hospital that has a psychiatric absolute mental illness, but also is a very late stage, high medical cancer patient, we try to work and say we can't medically appropriately care for this person. We can on the mental health side, but not on the physical side. So there's a little bit of a back and forth there, but it really is wide ranging in terms of the types of conditions we see, both on Title 25 and Title 7. And again, we don't have the ability to filter out, and we try to do first come, first serve as well. So if we get a court order, they're on the list, they're on the queue, so that we don't have chaos. I'm not putting my thumb on the scale saying move this person up. And that's a real frustration for your law enforcement system, because you do have extremely acute individuals that sheriffs and detention centers are holding and saying, we've got to get this person out now. But how do you square that with another detention center where you could opine that it's not as severe as a person, and we start moving folks on the wait list? So we try to be extremely, with very rare circumstances, moving that around, try to be extremely fair. But Representative Wasserberger, your most acute individuals that we see, that this bill would really help the sheriffs and detention centers not only offset their cost and help their staffing, but also potentially insert some more treatment and stabilization to the facility. It's really around schizophrenia, schizoaffective disorder, extreme depression disorders that result, this is not a clinical term, but we see it every day, the types of conditions that are resulting in exceptionally difficult behaviors for whether it's law enforcement or whether it would be our facility. Those are the types of folks that require additional staffing, require seclusion from the general population in a jail. And that's what stresses the system so hard.
Thank you. Additional questions? Follow-up, Representative Wasserberger.
Okay, thank you, Madam Chair. And then of those folks that you see there with that that are struggling with that schizophrenia or extreme depression, do you know what the average hold time is for them that they're sitting there waiting? Is it 6 months, 5 months, 4?
Director.
Madam Chairman, thank you. Representative Wasserberger. I'm glad you asked, and we're happy to follow up with a report. Years and years ago, we built a data system in-house for the state hospital. And we have up to the day, really up to the hour data on that. Right now, I'll give you just some high level numbers on average. We're typically seeing on average around 160 days, 140 to 160 day wait time on Title VII inpatient orders. Now, on the evaluation side, a court's ordering someone to be evaluated by the state hospital to determine if they were competent at the time of the offense or fit to stand trial. We handle most of those on an outpatient basis with forensic psychologists traveling to the jail to evaluate the person, or doing that in some cases over video. If the jail and the county can accommodate that, we will do that in cases. That's the bulk of that is really around 30 to 45 days that we complete those evaluations. So much more rapid on the evaluation side. But inpatient admissions on the Title VII forensic side, that's the real issue here. And I'm sensitive to, you guys will hear from sheriffs to say it's unacceptable to have someone sitting for 3 months, 4 months, 6 months, 9 months, depending on the case. Why can't we get them into the state hospital? I'm so sympathetic. We agree it's unacceptable. It's these structural problems we have of capacity, available beds, the volume of orders we're getting, and issues that I really think this permissive bill allows us to partner with them to try to help.
Thank you, Director. Thank you, gentlemen, for joining us. Any other government agencies want to come forward? Director, good morning. Welcome to Labor and Health.
Pleasure to be here. Good morning, Madam Chair, Madam Vice Chair, committee members. My name is Dan Shannon with the Department of Corrections. I appear before you today mostly just to answer questions, as there's a similar program that allows us to reimburse. It's been in place for years with Department of Corrections and our county sheriffs that we can reimburse them after 10 days. The bill before you is really for those with mental illness with their pretrial detentioners. On our state side with the Department of Corrections, they're convicted felons. But I would bring before you that these individuals, once they go through the process, they just don't become cured or disappeared. More often than not, we'll have to care for them for many times 20 years to life or for the rest of their natural life. So the sooner that we can address these needs, the better. Madam Chair, I stand for questions.
Any questions of Director Shannon? Seeing none. Thank you for joining us. Thank you for coming.
Thank you, ma'am.
All right, let's open it up for public comment on House or Senate File 10. Good morning. If you'd state your name and we'll hear your take on the bill.
Good morning, Madam Chair. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. I would just like to echo the comments that we've heard in testimony. I think the people that spoke before laid out the issue. This is a very simple bill when you look at the language of the bill, but the ramifications are very, very deep and give us the opportunity to build contracts and further our relationship with the Department of Health. I would also like to mention we found ourselves a lot of times in these opposing viewpoints, pointing fingers at each other. the work that has been done both with the Judiciary Committee and with ongoing meetings with the Department of Health and sheriffs from across the state over 2025 has been some exceptional work. And to try and make this as simple as possible and be able to allow a 7-bed jail and a 250-bed jail to have differing contracts with the Department of Health to provide differing services based on the capabilities of those facilities is something that we're really looking forward to trying out. I would add that when we look at the mental health world, law enforcement doesn't want to be in the mental health world. We've been there the whole time, kind of that first line of defense, especially in rural America. And it's time that we be, part of that discussion on building the future of mental health treatment in Wyoming. And I look at this from the Title VII standpoint as the foundation. We need language like this in statute so that we can build contracts and further relationships with the Department of Health and build the foundation for ongoing mental health attention from the law enforcement perspective. Now, this bill touches just on the Title VII, but our work is expanding in the Title 25 and the general public safety world, and those are all intermingled and so forth. But from the county jail standpoint, I think they've testified this morning that it paints a pretty good picture on that struggle at the county jail level. And I would just like to add that the struggle of having somebody with a severe mental health issue within the jail is not only kind of a safety concern for that inmate, but it also is for the staff. You have the higher propensity for use of force incidents. You have higher liability concerns. You have that ongoing time where treatment is not occurring. And we firmly believe that there are jails within our state that are already doing a pretty robust mental health treatment program that are willing to jump into this and start that treatment and restoration in the county jail. And because that is going on, it should lessen the time frame that somebody in one individual or more is in that pipeline for the state hospital and open up the opportunities for those jails that just don't have the capacity. They might have one inmate every 2 years that would fit into this category. And it's just not worth it to set up any kind of mental health treatment program. But it also contemplates that idea of maybe we can work with local mental health or maybe contract mental health on the local level and receive some sort of reimbursement from the state to provide medication or some other treatment on the local level that jail is not set up to do. So I think the outcomes are endless possibilities for law enforcement to provide better services to those inmates, for the state of Wyoming to work kind of outside the box and provide this treatment spread out over a greater geographical area with partnerships with the 23 counties. And we would just like to see this bill make it to the finish line. It's one of the most important things that our sheriffs are seeing in this session. And I'd be happy to answer any questions if you have any, Madam Chair.
Thank you, Mr. Thompson. Committee, any questions? We're a quiet bunch this morning. Okay, thank you for joining us. Any further public comment? Senate File 10. Okay, anybody online? Okay, thank you. All right, I will close public comment on Senate File 10. Committee, what is your pleasure?
Second.
Okay, the bill has been moved by Vice Chair Ottman, seconded by Representative Wasserberger. Discussion, amendments.
Madam Chairman,
Representative Yin.
I'll move your proposed amendment. Madam Chairman, just for the public's edification, the proposed amendment is on page 1, line 5, after amendments, semicolon, insert requiring reports. I think this is basically just a technical.
Representative Yin, can you speak a little closer to the mic? I
Sorry.
can't even hear you.
Madam Chairman, yeah, it's still early for all of us. For the public's edification, Madam Chairman, the amendment is page 1, line 5, after amendments, semicolon, insert requiring reports, semicolon. I believe this is just a technical correction.
Thank you, Representative Yin. And we did have a second. And Mr. Caldwell, you have that? Great. All right, discussion on the proposed amendment. See none, question being called. All those in favor of Representative Yin's amendment, please state by show of hands and a voice vote. Please state aye. Aye. All opposed? Okay, that amendment has passed. Further amendments, Senate File 10, discussion. Representative Closton.
Thank you, Madam Chair. Just to me, what a wonderful bill. You know, we're having people who need treatment that aren't getting it. Which puts, this person at risk. They're being held longer than they need to, and also puts our staff at risk. These people, if they could get the mental health care that they need sooner, just better overall. And I just want to commend everybody for their work on this.
Thank you, Representative Clouston. Great comments. Anything further? Question being called. Mr. Caldwell, if you call the roll on Senate File 10.
This is a roll call vote for Senate File 10 as amended. Representative Clouston,
Aye.
Representative Guggenmoss,
Aye.
Representative Heft, Representative McCann, Representative Ottman,
Aye.
Representative Thayer,
Aye.
Representative Wasserberger,
Aye.
Representative Yen.
Aye.
Chairman Rodriguez Williams. Madam Chairman, that is 9 ayes.
Thank you. Senate File 10 has passed committee. We will move on to our next bill for consideration, and that's Senate File 5, Hospital Bankruptcy Proceedings. It's now on the table for the committee's consideration. And we have with us our very own Representative Thayer. Good morning. If you'd walk us through the bill.
Good morning, Madam Chair and Committee. This morning in front of us, we have Senate File 5. We are talking about statutes 18-8-109 and statutes 35-2-348. This is giving memorial hospitals and hospital districts options, not just to terminate or dissolve. During the interim, we reviewed Chapter 9 U.S. bankruptcy codes to make sure that this bill aligns with all those rules. We also heard from Wyoming Hospital Association and the counties, making sure we're dotting all of our I's and T's. So now I'd like to just walk through the bill. In Section 1, we are at the bottom of page 1. This starts the dissolution, which we are changing. And at the top of page 2 in line 1, this is where we're inserting the language that they have the opportunity to file bankruptcy and not just dissolve or terminate. Again, in lines on page 2, starting at line 6, number B, talks about our guardrails. We definitely want guardrails. And so this talks about that they have to come up with a petition. They have to go through the steps with the commissioners and do all that due diligence. Then again, on line 13, section C, another guardrail. This is not about just forgiving their debt. This is about resolving and working to reorganize with their creditors. So this is not just a clean slate. As you can see, like on line 17, there has to be a plan and following again, all the bankruptcy codes. Then we go at the bottom of page 2, 35-2-438. This is talking about the hospital districts. Again, on the top of page 3, it is inserting that option again, that they can file bankruptcy and not just dissolve or terminate. So again, just inserting, just amending. And then there is a new section D in 35-2-348 where it creates those guardrails again, that there has to be, they have to come together, they have to have a plan, they have to post it on the website for the hospital districts. So again, this was a topic. I think we reviewed it pretty clearly in interim. The last thing on section 2, there was one change that came over from the Senate chamber or from the other chamber that they made this effective immediately for if this option is needed. Again, this is in big picture. This is sustaining our healthcare in our state, in our counties, in our own backyard, and giving healthcare options and not just dissolving and terminating. that there is a chance to refile and keep those needed medical services in our community. And I stand for questions.
Thank you. Committee questions, Vice Chair Ottman.
Thank you, Madam Chairman. Representative, thank you for this. Do you know what the procedure is towards creditors under a bankruptcy 9?
I would have.
Representative Thayer.
Thank you, Madam Chair and Representative Ottman. Again, I would phone a friend, but when we walk this through, and I had a discussion with Senator Crum before I walked in here, he had another meeting where he would have been here. We did follow all bankruptcy codes. And so there is a plan written in Chapter 9, and this bill does follow all those requirements.
Okay, thank you.
Thank you. Any questions about the bill? Representative Klauston.
Thank you, Madam Chair. Thank you, Representative Thayer. Do you know, and maybe somebody else could speak to it too, but any recent hospitals that have had just to dissolve lately because of bankruptcy?
I'm gonna,
Representative Thayer.
as currently there was one, I want to say up north in our state, but that was a private hospital. And so they had their own rules. So it was not in in these two well, that was a hospital, so it wasn't a district. So they had and this is one of the reasons this bill is in front of you guys, is it was a hospital up north and they were able to file Chapter 9 and reorganize. They didn't have to close. So this was a tool, but again, that hospital was a private hospital and not a memorial hospital.
Thank you. Committee, any other questions for Representative Thayer? Okay, seeing none. Thank you for presenting the bill. Any government agencies like to come up? We'll open it up to the public. Good morning. Please state your name. We'll hear your take on the bill.
Morning, Madam Chairman, committee members, Eric Boley with the Wyoming Hospital Association, and I want to thank you, Chairman, for giving me a heads up that this would be in committee today. As you know, we worked through the interim on this, and I think it's an important topic, and I appreciate the work that the committee's done. I can answer a couple of questions that were asked for you, Representative Ottman. Under Chapter 9, the court actually appoints a person that will actually work with both the creditor and the creditees, or with the hospital and those they owe money to. And they put together a plan on how those debts would be repaid and reorganized over time. And so that it doesn't dissolve or diminish their requirements to repay it. It just puts in place a plan so that they can spread it over time and stay solvent. Representative Klauston, your question, we've had one hospital. So in the last 32 years, we've had one hospital that closed. And this option wasn't available to them at that time. It's a hospital district. And they were closed for a number of years and then finally were able to reopen. What I would say is when a hospital closes and then has to reopen, it's very, very difficult because you lose all of the staff. They move. It's hard on the communities. I would also share with you that if this had been an option 2 years ago, one of our hospitals that struggled mightily, and Representative Thayer and I have been working for a long time to help one of our hospitals. If they could have utilized this, it would have made the burden that they've gone through for the last 2 years much easier. And that's really the impetus of why we brought this. We had county attorneys take a look at it. The county commissioners actually wanted to use Chapter 9 and couldn't because statutorily they weren't allowed to do that. I had 2 large firms take a look at our statute and hoping one of them could find a loophole that might allow bankruptcy for that hospital, and it didn't happen. And so that's why we brought this. There was a hospital in the northeast part of the state about 3 or 4 years ago that actually used Chapter 9 reorganization. And they are a hospital district, but because of the way that they're structured, they're also under a different tax ID, and I think they're a 501c3 and had the ability to utilize Chapter 9, and it saved their hospital, and they made it out of that. And so, as we were looking at this, we thought we already had, because of that situation, we thought hospital districts could already use Chapter 9. but they can't statutorily. So we thought we were only dealing with memorial hospitals. We have 5 of those in the state right now. And then as we looked at it and as our attorneys looked at it, they thought, well, if we're going to fix it for memorials, we ought to fix it for hospital districts too. And I would tell you, I'm concerned. We have hospitals that are struggling right now. We have several that, according to national reports, Becker's is a great big publication of hospital statistics and data. We have 3 or 4 that are in immediate danger of closure. They have less than 10 days cash on hand. And so as we were working this over in the Senate, that's why the amendment to make it effective immediately as opposed to waiting until July, just in the event that something happened. And realistically, they probably couldn't get to bankruptcy by July, but this at least gives them the opportunity to start that process. With that, I ask for your favorable consideration. It passed unanimously through the Senate and hope we can get it through the House and answer any questions.
Thank you. Any questions, committee? Mr. Boley? Seeing none? Thank you.
Yeah, thank you for your work on this. Appreciate it a lot.
Any further public comment? Anybody online? Okay. All right. We will close public comments on Senate File 5. Committee, what is your pleasure?
Second.
The bill has been moved by Representative Gugemas, seconded by Representative Wasserberger. Discussion amendments. See no discussion or amendments, and the question being called, Mr. Caldwell, if you call the roll on Senate File 5.
This is a roll call vote for Senate File 5. Representative Clouston,
Aye.
Representative Gugemas,
Aye.
Representative Heft, Representative McCann, Representative Ottman,
Aye.
Representative Thayer,
Aye.
Representative Wasserberger,
Aye.
Representative Yen,
Aye.
Chairman Rodriguez Williams. Madam Chairman, that is 9 ayes.
Senate File 5 has passed committee. We have no further business on the agenda, so this meeting is adjourned. Thank you.